telling us what to do. Yeah. This will be under Article 227 Constitution of India. The petitioner has a say that of the order dated 22/9/2021 passed by the Debt Recovery Act by Chennai insofar as it poses a condition of deposit of.
Yes, my lord. It may be passed. We will make our submissions.
It's too late now. We are now passing the order. There is no point. You are conceded no, that it has to be dismissed. What is there? What is the fun in passing it over? It's not a game, right?
My lord, we are not conceding, my lord. It's just that we have not been able to. I apologize, my lord. We're not conceding to dismissal. It's just that we have not been able to concede with. I mean, abide with the interim order.
We are not saying we are giving. Don't interrupt. This is very irritating, right? You will not render assistance to the court. You will not tell us the facts. When the court is dictating the order, you will interrupt. Please don't do it.
My apologies. My apologies.
Please don't. Addition of free deposit of an amount of rupees 1.50 crore into installments in a period of 4 weeks. Paragraph. Fact giving rise to filing of this petition will be stated that the petitioner is a guarantor of loans availed by respondent number 3 and respondent number 4 from respondent number 1. But respondent number 3 is a fact giving rise to filing of this petition will be stated that respondent number 3 is a partnership firm and respondent number 4 is one of its partners. The firm availed of financial assistance from respondent number 1 to the extent of rupees 50 lakhs and corporate loan of rupees 20 lakhs on 31/3/2014 and 20th September 2018. The aforesaid amount of loan which was availed for the purposes of business of the firms was to be repaid in 5 yearly installments. The petitioner is a guarantor to the loans which was availed of by respondent number 3 and 4. The petitioner had mortgaged the piece and parcel of vacant site bearing number 33, Nanjappa layout 11th plot, Narayanpura, CNC, comma, Khata number. So all this is paragraph 3 given. At collateral security, secure the aforesaid loan. The respondent number 3 and paragraph. The respondent number 3 and 4 failed to repay the loan. Thereupon, the bank issued demand notices and a sale notice dated 8/11/2012 was issued, in which it was stated that the scheduled property would be put to sale and disposed of via e-auction between 26/11/2012 to 11/12/2012. The petitioner was served with a notice dated 29 December 2012, by which he was informed that in furtherance to the sale notice, the sale did not take place. However, by a notice dated 5/3/2013, the petitioner was informed that scheduled property was sold to respondent number 5 on in an auction. the respondent number 5 thereupon, the respondent number 1 thereupon approached the additional chief judicial magistrate under section 14 of the Surface Act, and an order was passed directing handing over of the possession. The petitioner, along with respondent number 3 and 4, challenge the aforesaid action of the respondent bank in alienating the property in favor of respondent number 5, the auction before the uh, and uh, and as well as challenge the validity of the sale certificate dated 1/3/2012 issued in favor of the respondent number 5. The petitioner's interlocutory application filed by the petitioner was dismissed by the debt recovery tribunal by an order dated 16/4/2014 on the ground that the appeal was not filed within the period of limitation. The petitioner thereafter filed an application for the petitioner thereafter approached the debt recovery appellate tribunal against the order dated 16/4/2014 and prayed for condonation of delay in challenging the auction sale. The petitioner also filed an interlocutory application seeking a waiver on free deposit amount to admit the appeal. Debt recovery tribunal, by an order dated 5/2021, directed it was 22/9/2021, directed the petitioner to deposit a sum of rupees 1.5 crores in 2 installments within a period of 4 weeks. So the copy the aforesaid after background this petition and the filed. Paragraph. This court the court, by an interim order dated 12/10/21, had directed the petitioner to deposit a sum of rupees 69,89,000 before the debt recovery tribunal and had granted the stay subject to the aforesaid condition. Thereafter, the time in making the deposit of the aforesaid amount was extended up to 26/11/2021. However, admittedly, till today, the petitioner has not complied with the aforesaid interim order. Paragraph. In view of law written by Supreme Court, that very case, 43(5) Supreme Court has held like this. In view of the tribunal, this court had directed the petitioner to deposit 50% of the amount up to what date? Up to that's now you written 26/11/2021. However, and had stayed the order passed by the debt recovery tribunal. However, till today the opposite amount has not been deposited. The order passed by the debt recovery tribunal is discretionary in nature and does not suffer from any informative or interference of this court in exercise of supervisory duties in the regard. No, for the aforementioned reason, do not find any measure. Same faith can be here by this. But 10. Yes, you are 2 weeks. 2 weeks. 11 2 weeks. Next time, you and the applicant submit Next is G and H. The aforesaid submission is taken on record. The requirement of filing the eligible copy of an extra G and H is dispensed. Yes.
Number 12, the Venkatesh Ji.
How much time? 4 weeks.
Number 30, the Prashant Fakirapur.
Yes, Mr.
The Jeevan General.
Ah. Which day? Finish. After 23rd, 24th. All right. Which is the corrected map? All right. Order. What order? What order has been passed? All right. All right. This is Gautam Bharadwaj when it comes to the concept of the applicant undertakes to apply with the office objections within a week. This for analogous hearing along with IA number, WA number 120/2022 on 24th February 2020. 60. All right, 60. All right, 60. The same order complies, wait for a week's time to comply. IA 2 of 22 dispensation for the reasons assigned, the requirement of filing production of to ensure distance with IA is allowed. List on 22nd February or 24th, sorry. Say 13 and 16 offices directed to reflect the name of Mr. Gautam Bharadwaj as counsel for the applicant.
Okay. Number 14, Sri Balram Rao.
Lordship, serial number 14 and 15. Pray for 3 weeks time, your Lordship.
3 weeks time.
Number 17. Karuna.
Report is fine. What report? Actually, you had appeared, right? Where is the report? Where is it?
Yes. Personally, they have come from hospital and handed over to him.
What is feasible? No, we don't know what is. The report was directed to be placed before us in a sealed cover. What are you doing? Is it a report or what? This memo. Memo. Where is sealed cover? Let them file this. We take it up in password round. Please file sealed cover, whatever, or hand it. If you are unable to file it. You should hand over the sealed envelope. No?
Number 18, hearing on here.
Your Lord, in this matter,
Yes.
I'm being led, Your Lordship, by Senior Counsel Ms. Jaina Kothari. Unfortunately, I'm being led by Ms. Jaina Kothari, Senior Advocate in this matter. Unfortunately, he has some personal inconvenience. May I request a week's time for this matter to be taken up?
He is praying for adjournment week's time. Counsel is not available. Senior counsel. Yes, Mr. What do you say?
Your Lordship, I beg your pardon. I couldn't hear the counsel on the other end.
You have to speak. That mic is not working. Yes. Okay. Please speak into the mic. He wants to listen. What are you saying?
Who ordered the call for report earlier? Okay, on 18/2/2019, conducted survey. Late and thereafter, a legal order was on 2nd June 2021.
Yes, Mr.
Okay.
What do you say?
Government will be busy.
Yes.
Your Lordship, may I only submit the application that my learned friend is talking about is in fact filed, and we want to file objections, and I state that we will conduct the hearing on that application on the very next date. It's only that Ms. Jaina Kothari has been leading this matter for some time. It would only be appropriate that she be present on the date on which this application is taken up. Any date.
Any date, tell us. 25th February is fine.
25th. I'm obliged, Your Lordship. 25th.
Huh? Which one? It will be taken. It will be taken up. What's his name?
D.R. Mohan. D.R. Mohan.
Mr. D.R. Mohan, learned counsel, submits that arguing counsel, Mrs. Jaina Kothari, the senior advocate is not available. He therefore pays for adjournment. Mark their presence, everybody is right. Based on 25th February 2023.
I'm obliged, Your Lordship.
Sri N. Kumar, government advocate. Sri Gopal Dular Mane, Sri Prasanna Kumar, Sri N. Ketli, Sri Chandrakant Gowde. The last time the individual application was not on the other side. They took time to file up.
Not there. It was, let's see. No, next week. What is it? We don't know. No, according to you. First round, please wait. Heard on IBF. But on IBF, whatever further orders regarding after hearing learning for the reasons assigned will be supported by an sufficient cause for continuation of delay of 92 days in filing the appeal is made delay in IA's allowed. Let the appeal be listed for orders on admin. Yes.
21. Vanita here.
Hold on. IA 1 of 22 reasons.
I appear for the appellant in this case, my lords.
Which newspaper, madam?
Serial number 21, my lords.
Let notice be published in Delhi.
Paper publication. Yes,
Indian
sought for
Express,
minutes.
published from Bangalore for appearance of the respondent before this court on 22nd March 2022. Or the appellant shall file a copy of the newspaper news on the registry of this court. Accordingly, IA 122 is allowed. Yes, madam, allow.
Much obliged, my lords.
Counsel for appellant shall take necessary steps within 1 week and shall file a copy.
Much obliged, my lords. 22/3 the date fixed, my lords. I beg a pardon, my lords.
22nd March, madam.
Much obliged, my lords.
2020.
Please, my lords.
Yes.
22. The Raghavendra Ji Gayatri. The dear doctor.
We hope the counsel for appellant has no objection. Huh? You must be knowing your friend better, right? Huh? Data. Because we are data counsel respondent wait for. What a judgment to enable him to file objections. What? To enable him to file readers of judgment this immediately after 1 week.
23. Srimati Anuradha Agnihotri, Sri Rudra Public. Frequently is not waiting for you. On the order of the final order of the Supreme Court. You have to approach the National Commission. You have wrongly approached the Supreme Court.
Oh, what is this amendment? Please supply. Please supply. Give him a copy, no? Extra copy we can allow just now. See, only change of name. Please see the amendment. See the amendment. What objection? See, if it's only change of name, what objection? Until unless you have knowledge that this information is incorrect and this is not the name, what objection to application for amendment from this nature? Yes, right, correct. Third on IA 1 of 21 reasons assigned taking into account nature of proposed amendment. Same is allowed. Let amended cost as simplified within. No, within. Week. It's not that simple, right? Within 1 week. It will come up. Don't worry. Huh?
On the order of the consumer state council, they have proposed national
So
commission.
is there any stay operating against you? What's the problem?
They have the economic court was pleased to pass the order,
Huh?
not to take the coercive steps in the law chapter.
Stay order has been passed. We have allowed the amendment just now. We understand it needs to be heard 23rd February. List on 23rd February. Yes. Same. He's the pin. All right, third on I is allowed. 23rd February.
Number 25, CA Sanmati,
Your Lordship, I have filed application for dispensation of production of certified copy. My certified copy is produced in connected matter 290 of 21.
And so it's discussed it in the result I is allowed.
The matter is already admitted, my lord.
Admitted. All right, fine.
26, Srimati Tanmay Rajkumar,
Notice.
number 27, Sri Rupoji Rao HS,
What is
I
this
appear for
IA
the
for?
petitioner, my lord. I appear for the petitioner in this matter.
But
The
why have you
respon-
filed the IA for listing?
That's filed by the respondents, my lord.
One minute. No order. No, it is for, not, it is for listing. So no orders are required. It's already listed. So what is your this thing vacating stay you have filed? What has
My lord, one submission at the outset, my lord.
he is speaking to the mic. He can't hear.
My lord, sir, one
You are a
submission.
young man. Why you should come to court when Mr. Joshi
I'll-
can come? Why you
I'll
should
come, my lord. I'll come, my lord. A date may be given, my
okay.
lord. I'll come. I
So
also
have you
have to,
understood what?
I also have to produce certain judgments which I'm relying on. I'll come physically and argue, my lord. A short date may be
You
given.
have to,
Indeed, my lord.
you have to ascertain Karnataka State Consumer Disputes Redressal Commission
Indeed, my
whether
lord.
the appeal lies. You are saying that the order is without jurisdiction.
Yes, my lord. I've stated
That's
that.
why one fool. We
But-
don't know.
Two
Get ready.
submissions, my lord. Two submissions on
Oh, if
maintainability.
you are ready, then please argue. Otherwise,
No,
you
my
will
lord, I'll
not
come.
argue.
That's what I want to produce.
When will you argue?
Any day other than 17th this week, it may be given, my lord. I'll come.
Yes, Mr. Joshi. Other than 17. 21st, Mr.
Indeed, my lord, I'll come.
No orders are required to be passed on IA 1 of 2022 as the matter has already been listed. Accordingly, same is disposed of. Learned senior mark is present also. Learned senior counsel for respondent submits that in this petition, the petitioner has attained the validity of the order dated 4/1/2022 passed by Karnataka State Consumer Disputes Redressal Commission. It is further submitted that against the aforesaid order, an appeal lies under section 51 to Consumer Protection Act 2018, 19 before the State Commission. In view of aforesaid submission, learned counsel for the petitioner prays for adjournment to enable him to examine the aforesaid aspect. List on 21st February 2020.
Interim order has to be extended, my lord.
So we don't know. Interim order.
There's an interim order, my lord.
Shall continue till next date of hearing.
Much obliged.
Interim order, if any, then say list on 21st.
Finalizing, number 28, Sri Raghavendra CH.
Oh,
CH-2.
yes. Yes. Ah. Hmm. You have examined that aspect, right? Did you? Yes. 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 Who had appeared before the respondent? Before the learned second. No, respondent. So please supply a copy to him. We'll hear you. No, his name is not there. Who is there? Supply copy to Mr. Jeevan. We will hear you on 23rd. 23rd February is all right. Valid senior counsel for the. No, we have. Please write. Valid senior counsel for the. Counsel is appearing. So, will supply a copy of the rate petition to Mr. Rate appeal along with the extras to Mr. Jeevan J. Nirali. Based on orders on admission on 23rd. Here on 23rd. That's right. No, the bench is only till 1:30. It will take half an hour. Everybody else will wait. That is the idea. Yes.
29.
You say, all right. So the issue is the provisions of GST are not applicable with respect of work contract, right? 1/7/2017. That's the issue, right? You should look, Mr. So and so. You should learn the art of brevity, Mr. Young Counsel. That's why we are telling. So you are saying something. Tell us in first two sentences, this is the issue involved. Then say what happened, whatever you want to say. You should learn the art of taking the bench with you within 2 minutes. If the court is not within you, within 2 minutes, it will never be with you. Right? Yeah, just so that you will follow it, and that is the hope we said, otherwise not necessary. You are challenging the virus also, right? It has to go before the appropriate bench. You can't hear. No virus, yes. So virus of provisions of section 7(3) of the GST Act is under challenge. Let the petition be listed before the appropriate bench. Let's see if it comes.
Number 30, the S anomaly.
Oh, yes. Oh. Really, Shankar, senior counsel, the petitioner heard on the question of admission notice. On admission as well including. Next day, let them be served. Yes. Yes. So, what happened, madam? And what happened? The appeal was.
He can make out. Lord, the hearing has taken place as indicated by me on the last occasion.
He told us that appeal before you was fixed for hearing on 11th of February.
My lord, the NMC participated in the hearing. My lord, I had mentioned that they had.
He appears for Union of India, but you are better informed. She doesn't know whether appeal is fixed for hearing. Nothing. She doesn't know. So what happened? 11th February, Mr. KT.
Not the hearing took place. Now they'll be passing.
Order.
As informed by me.
Mr. Ravi Shankar, what are your instructions? No, but hearing has taken place. Madam, find out. I mean, the hearing has. The Mr. KP is telling us on 11th February 2022, the appeal was fixed. Arguments have been heard, and as you have heard, Mr. Ravi Shankar also telling us that arguments have been heard. So, what orders and by what? This you can find out at least today.
What is matter?
We'll pass it over. No, tomorrow. It has not been. Please find out. 15. This thing is that otherwise he is insisting for an entry prayer. 15th February, second round of counseling starts. You understand? Please find out, madam. We are giving you time. I understand. Tomorrow the counseling begins. So we are passing it over. We will take it up at around 1:50. Please find out. Right. Mr. Ketty, you find out. Yes, you find out by we are passing it over. We will take it 15 minutes past 1. Right? You find out what has happened. You also find out from your. They will also find out. You also find out. 1:15.
If they mention the name of the college, this is referred by the name of the college.
Try to find out. They will also try. We have requested. Find out, madam. We have requested all of you. If you are unable to tell us, we will pass an order. We will have to permit them to in second round of counseling. What can we do? We are giving you a chance, an opportunity.
For admission, number 32, is given
Please, my lords, I'm appearing for the respondents, Your Honor. My lords, we've been following up with the appellant's counsel, but we haven't received the copy of the appeal yet.
Oh, hey, Mr. Jeevan, please supply. Huh? You please, he wants a copy of the memo of appeal before admission. After admission, we will give you copy, right, Mr.
My lords, if it can be given in advance, my lords.
What is it? See, Mr. Admission is a matter between the appellant and the court, and we feel that the respondent, except in case of this thing that where appeal itself is not maintainable or something, you don't have any locus to oppose admission. Right? That's the. What will you do? You will say that these questions do not arise for consideration, right? This is what you are going to tell us, that these are questions of fact which do not arise for consideration in this appeal. This is your argument. Right?
Yes, my lord. Yes, my lord.
That's it. What on the question of admission 19, 21, 22? Three questions. You should notice on behalf of respondent is what's your name, Mr.
My lord, Akshay Uppal.
Okay, Uppal, learned counsel for respondent. Let a copy of memo of appeal along with the research be supplied to you. Yes, you will get a copy now within 1 week.
Grateful, my lords.
33, Sri Madhu Yendra, Srimati Vanita Care.
What is Mr. Hindalco Industries citation? Yes, we were looking for it, we didn't get it. Huh? Wrong? No, what is wrong? You have said so in your district. Birla Copper has been overturned by Supreme Court in Hindalco Industries Supra. So we tried to find out where is Hindalco Industries Supra. We couldn't get it. So we are asking where is it?
Relevant here.
We don't know. How is it? We don't know whether it's relevant. B28, page 26C. Page 26, B28. What is Supra? So we were trying to ascertain none of your preceding pages Supra. So otherwise you delete it, it's not relevant. We are sure you must not have drafted the appeal, but whosoever has drafted, ask him to be more cautious.
However, the other commissioner has held that it is not possible to verify the veracity of the statement taken by the applicant. Also, the exercise we have as well as the supporting we find that respect of the above demand need to show the claim of either party statement of verification. It was not denied by the regulations of the not submitting here. However, the claim was that it was not possible to reach a have one record. Verify the statement rate. That's what we find. That in the interest of justice to resolve the matter back to the authorities, for verification of the claim of the other, including that one verification. The finding of the paragraph.
Yes.
There are 837. Rectification of mistake application was right. And even in that, the requirement says that it should go back. Because now we are from you of this order. Criminal actual finding said it should go back.
Which other matter?
64 of 2018.
All right. Mr. Jeevan, take notice. All right, Mr. Jeevan J. Nirali, learned counsel, appears on behalf of respondent. Office is directed to reflect his name. List along with CA 64 of 2019. 21st. Yes, yes. 24th, Mr.
I am appearing for the respondent associate.
28th.
My lord, I am appearing for. I am appearing for the respondent associate, my lord. The issue in this appeal relates to the taxability and the rate of tax applicable, and therefore not maintainable before the High Court, my lord. If that issue is to be decided, may be listed for hearing and make the submission in person, my lord.
Nobody's our predicament is nobody is appearing for the appellant.
If my lord can fix the hearing on a Thursday, Friday, as usual, and the tax matters are being heard, I will appear and so that the even the
tax matters are listed all the days, 5 days a week. There is no days reserved.
Obliged,
So we don't have any other thing except tax.
Yes, my lord. This particular appeal, my lord.
Our problem. Please, we have told you again. We are telling you that counsel for appellant is not there. We hope that you are not representing the appellant, right? Either we have to pass over or dismiss it. Whatever.
My lord, it can be urgent next week, my lord.
Pass over. All right, we'll bear that in mind. Pass over. Once it takes you, tell us when the case is called in pass over. Yes.
Number 35, K.V. Arvind.
Yes, Mr. Arvind.
My lord, the questions, my lord, involved, my lord, is a search was conducted, my lord, and certain unaccounted, my lord, capitation fee collected by the medical colleges, my lord, for admissions were detected. And those additions, my lord, irrespective of, my lord, the evidence found in the course of search, my lord, the same has been deleted. My lord, question number 1, 3, and 4, my lord, would be relevant, my lord.
36, K.V. Arvind, K.R. Vasudevan.
My lord, I'm appearing for the respondent.
TP matter, 2 questions, my lord, at page number 9, 1 and 2, my lord.
This is transfer pricing. Notice on behalf of the secreted by Mr.
Ankur Pai, my lord.
Ankur Pai. Mr. Jeevan.
Number 37.
No. See, last date also you sought time. The appellate tribunal has placed land for judgment of the High Court against which you have appealed. So then you, 27 January, you took time to find out what is pending. So what should we do? What had been the judgment? Why we should not follow? We have 2 options. We follow the judgment and send you to Delhi. No chances of this thing. Mr. Jeevan J. Nirali, on instructions, submits that the matter before the Supreme Court is fixed for hearing in the month of March. In view of opposite submission, let this appeal be listed on 5th of April 2020. Said March, so we have April, 5th April.
Number 38, Srimati Tanmay Rajkumar.
Yes, Mr.
The issue relates to transfer pricing adjustment on intra-group services, where the tribunal has remanded the matter on the ground that evidences are not available, despite all the evidences being filed before the tribunal. What has happened is, Earlier year, the tribunal has reminded the tribunal is consistent following that order despite the evidences having been filed without deciding. It's a hero remand without saying what methodology should be followed, what.
Voice is not clear, Mrs. Cracking. Mrs. Surya Narayan, your voice is cracking.
I'm sorry, Madam. I'm sorry.
Not clear. So transfer pricing, right?
Yes, madam.
The matter has been remanded.
That's right, madam. In fact, the cross appeal in 1921 of 2022, the same questions have been admitted.
Huh? 21 of 22 has been admitted.
That's right. That's right.
Learned senior. So how many questions, Mr. 11, 7?
Around 7 questions have.
No. It's called duplication.
Questions 1 to 5, if my lord admit, because questions 6 and 7 will get covered in the velocity.
5. We should notice this along with ITA 21 of 22.
Number 39, Sri Ajay Kumar Patil, Sri NKT, Government Advocate, Sri NK Ramesh, Sri Ashok Desai, Sri C.R. Gowde.
What is it? No, what is the matter about? Tell us. All councils are there. All councils are there. We can begin, right? How much time will you take, Mr.? 45 minutes. What is there? You told us it has already been heard.
Last time, my lord, that we go to the order pathway, the admission committee, and observe that as a matter, first they have to refund the fee as directed by the admission system.
To argue for 45 minutes. That's what we are asking.
Some documents, my lord, and 1 or 2 judgments which you would like to cite, that you know, beyond that, because that's one particular paragraph in Islamic academic, that is all that I want to read.
We'll hear you on 24th or 25th February.
Difficulty, my lord, is on 22nd examinations are starting. Last time they made that submission. The last date for payment is already over. Permit us to appear for the examination. 3 years we have completed. What they have been given, my lord, the last year fees, not this money. This amount we have not collected. 2 years, from last 2 years we have not been collecting. The fees were for the final year is getting 2 lakhs 96,000.
Directly they can refund the money. If they don't refund, necessary action to report.
That's what we are asking.
2 lakhs 96,000 we not have.
What is there to argue? He will read what to do. No, wait.
Last year fees.
No. What happens to the excess amount? There is a direction to you to refund. Why are you not refunding? No. He is in fact inviting adjournment. Otherwise, had I been in his position, I would have concluded it within 10 minutes. 10 minutes. I would have concluded. He is inviting adjournment. What can we? He says 45 minutes. We don't have time. The court is. What is there to argue, Mr. Patil? There is an order in your favor. What is there to argue for 45 minutes? That's it. You should have given us a synopsis. Hey, who will write all this? Ideally speaking, you should have given us a synopsis. That's very. Don't say in front of everybody, otherwise the youngsters will stop preparing synopsis. They will say everything is given in the petition, go through it. All right, that's the. Don't say it good that there are no youngsters. So we can at least ask them to give a synopsis. Otherwise, everybody will tell you that everything is written. So that's by that analogy, Mr. Patil, Why we should hear you? Everything is written, grounds are there. Why we should hear you? Tell us.
Page 108 of 58, 2020.
9858. Huh? 58.
Page 108.
108. Yes.
Page 111 has it this particular paragraph. Page 111.
No, fine. You know, we are taking it up. He told us, no, you did not hear him. Everything is there in the petition. He told us. We will do. Yes.
Page 111. Question number bottom. The committee carefully considered the content.
1 minute, Mr. Patil. Give us 2 minutes. Huh? Just 2 minutes to go through your petition. Order of admission overseeing committee. The last is 140. Start how much excess fee there will be. Start fee referred to on the last week. Yes, yeah. Which is 8114. Yes. The finding here. Government has not authorized to collect the above. Page 115. Which against 1,48,000. Yes. The report of the When the excess fee has been recovered from, since when? 2017, 18. So you came in 2021.
This petition is in the year 2020. The first petition was in the year 2018.
So this is 21.
20, yes, 20. The first petition, that was connected petition, as and when the demand was being made and we are not being permitted to appear for the examination, if you don't pay the excess fee, you have to this on the court. This particular case, not these students, my lord,
So
they are
same,
not the- they
just
are
a
not
minute.
prepared for the exam.
Same students have been filing repeatedly rate petitions for this.
No, not the same student.
Then-
Each petition is very different.
So I will 2020 9858.
Yes, 985.
Ah, so, so what are you seeking refund of the amount?
Yes, as directed by the Education Overseas Committee
Ah.
and as accepted by the government and the university.
And sixth, what you want to this thing appear in sixth semester examination?
This is the third MBBS part 2 examination. Third MBBS
Part 2.
part 2 examination.
When it is a
commence from 22nd of February.
but you have to pay the fees, right?
Yes, we have to pay the fees.
How much?
We have paid that fees according to us.
Which, how much is the fee? When did you pay?
6,33,000 which have been fixed by the government.
No,
We
when
have
did
been
you?
paying every year.
For this third MBBS,
For this third MBBS, my lord.
when have you paid?
Yes, that my lord, we have sought for a direction that should be adjusted or we are interested in management to adjust it against the excess fee that has already been collected and the balance we have paid. The total fee is 6,33,000. Some cases 1,48,000 has been paid as excess fee. In some cases 2,96,000.
Balance has been.
We
Balance,
have paid that balance 3,73,000.
When did you pay the balance amount is what we
That
asked.
I have paid when the academic session commenced in the month of September 2021.
how much did you pay?
I have produced the receipts. In all cases, I have produced the receipts.
Where is it?
Yes, I have produced. I have each case, I receive. Take 9858.
You should prepare the chart, Mr. Patil. And that's what we are saying. You should have prepared a chart. This case, this is, you are here to assist us. Right? Very petition. One page in this petition.
Yes, one page. Yes, one page. Page 47 of the IA. Page 47 of the IA for direction. Each and every student, all the 29 students have to get the chart.
So every case it will be different, right?
Every case is different.
We wanted you to prepare the chart in 2 pages for facility of reference.
Yes,
Like this.
That's why I have prepared. I have prepared it to see as an annexure. And we come to page 47 of the IA, which was filed on 20th of February 2021. In the 59,858.
What candidate copy? What is it?
List of students and fee payment details as of February 22, 2021.
What is the annexure?
Annexure award is DAG at 845. Amendment is annexure DAG.
No, this is from IA somewhere.
Yes, IA 1 of 21. By 20th.
IA 1 of 21.
21. Page 45 annexure DAG. Presentation by the parents to the college, to the registrar of the university, as well as to the vice chancellor. Saying that we have paid
47.
the numbers under which the years for which it has been collected.
No, you want us to certify in this proceeding under Article 227 that this is the amount paid and this is the due, and therefore you should be permitted to appear. Then
I can produce, I have produced the receipts. So that the court can follow you as to what is the extent that has been paid, but I have produced key receipts issued by the college. Each case.
In which petition?
Even if you give the receipts,
Yes,
my lord question is, will it be advisable for you to expect this court to determine the fees and authenticate the payment made? Even if you furnish additional document Can this court in this petition certify the payment balance, all the calculations we made?
No, I'm not saying that.
That's what my lord asked the question. Yes.
As far as payment is concerned.
Yes.
Now, just a minute. See what are the practical difficulties. You say everything to yes, yes to everything. There are 10 petitioners in this petition. This chart which you have prepared of one page contains student names of 26 students.
29.
It is 29. So where are these should contain, if you have prepared individually, it should only contain 10 names. So it is contained.
And before the latest representation, but these 29 petitioners are the petitioners before your lordship in the other cases also. They are the petitioners. There are batch of 5 or 6 matters. All these 29 are the petitioners. Only their names.
Where is the date of payment?
Yes. And you see, my lord, in that itself, mention my lord the name of the petitioner and the name of the father.
No, you first tell us about this petition. Which serial number?
No, the petitioners in this petition 959858. Where do you find their name in the list of page number 47? Is it in order or is it just at random?
So it is at random. It is at random. It is not in order. But I can point out my lord from the petition. First one is Bhumika. The petitioner is that.
Serial number 11.
Bhumika is serial number 11. He is the first petitioner in 1985. He is under the private category. The excess fee collected is 2,96,000 rupees. That has been collected for 2 years, 70 and 80.
No, when have you paid the, you said remaining amount of fee has been paid. Where is this chart does not contain the details. When have you paid an amount of 3,37,000? Which date?
Total amount, kindly see the third column of the right hand side.
3,37,000 doesn't mention the date when it is.
See, the 3,37,000,
Yes.
as per the column heading there,
Yes, this is
total amount paid as installment till the date full fee of 20. When was this amount paid? Is it your calculation of the excess amount paid by you? Is it the calculation of the excess amount paid by you or the actual payment of the 3,37,000?
Actual payment of 3,37,000.
So then the date of payment.
337 plus 296 comes to 633.
So when was this 3,37,000 paid? Date.
This was paid when the entire session commenced in year 2020.
Date. At the time of admission or when? Correct.
First fees we have paid 6,33,000 KEA. At the time of admission, there itself we paid.
Yes.
Next week in the academic year when it starts 2018 in the beginning itself, every year, September, October, we have paid 6,33,000. Again, they have collected 1,48,400. 2019, we have paid 6,33,000.
To sort it out, Mr. and submit a report to us. Because this can't be fact finding, disputed question of fact, we can't decide in the repetition. So you don't give the particular, when have you deposited, date of deposit? Date.
Yes.
So no date in the chart you are referring to.
Mr. Patil. No, Mr. Patil, just see page number 47.
Yes.
Just see, come to page number 47. The chart what you furnished. 47 of the IA.
Yes.
Just take serial number 11, Bhumika's example.
Yes.
Now you have the parent's name and then quota. Excess fee paid is 2,96,000.
Yes.
Year in which the excess fee paid 17-18.
Yes.
Then has the student requested payment? Yes. Then 6,33,000.
Yes.
Then 3,37,000.
Yes.
100%. The dates of payment is what we are asking.
Dates of payment.
This is your calculation of adjustment and excess payment.
Yes.
The date of payment, specific date of payment of 3,37,000.
September 2020. When the academic session commences. Without that, kindly see, I have paid.
Can't decide this issue. So we will have to permit them to appear, and Mr. you have to clear the mess. In fact, you are Mr. Ramesh, you are under an obligation that government order binds you, and we will ask you to submit a report because he is unable to assist us. You will prepare a chart in each case wise. Right?
I'll do that.
So just
I'll do it.
please. Now we are trying to help ourselves. Thank you. You have already done it. Facts are there in the petition. Rest everything is in the chart. Fine. So Mr. Ramesh, every case petitioner wise, you will ascertain from the petitioner and the university, this college, and submit a report to us that this is the amount due and payable, whatever, refundable to a student. What has been paid, what they have done, we are permitting to appear in the examination, them to appear. But you have to do this exercise, all these sorts of fact finding on the basis of this chart. No, at least speaking for myself, I am unable to decide. I can't decide. Speaking for myself, I can't decide like this.
University Council and help you prepare the chart. I'll sit with him in the office.
We don't know. He's your friend, do whatever. Yes. So, Mr. What has not chart like this? Read petition wise, where date wise, when what payment has been made, what is the excess, what is the amount refundable, when he has paid, payments date also, which amount, which date, and what is the amount refundable to each of the petitioner. So like WP 52425 2019, if there are 3 petitioners, just a minute. Just a minute, we are trying.
For a moment, 135 page 1.
Sorry.
1 minute. Page 135.
After we are permitting you to appear, that's what you wanted, right? Now, please, if we have to decide, or we should say that it should go before some other bench. I can't decide. If my brother writes the judgment, I can't decide this. I mean, in this form. No details, no particulars. One charge. You are saying 10 petitioners, giving the list of 23. No dates of payment are. We are telling you. We are trying to help you. Not helping. I don't. We don't know whom with you sit. That's your outlook. We are trying to tell you. Yes. So, Mr. WP 52425. If there are 3 petitioners, what is this thing? What have they paid? And see, and so therefore, and take steps to ensure that excess amount is refunded. No, whatever if they have paid the excess amount, this disputed question of fact cannot be gone into in this writ petition, whether or not they are saying, he is saying yes, they are saying no, we can't decide. This is not a fact finding inquiry. Admission overseeing committee has not seen it. We will refer, we can't give a finding in the writ petition that this much amount is due from A, this much amount is due from B, and this is C, and therefore they should refund. We can't do it. If it's a disputed question of fact, can't do it. And you understand, right? So prepare a chart. And how much time? So, all right, 10 days. Fine, third on IA, 1 of 2022. No, please. No, by all means. He will not run away, right? They will study for another term. No, even if they appear without payment of fee, then also they will be admitted to 4th year. This thing, no, where they will run away. They are well within your grip. Don't worry about them. Third on with IA number
2022, man.
52425. Where is IA? It's in this petition. 9850.
Morning share.
Other
only in the last matter. Yes, fine.
Only one case you have filed IA, right?
One case may not I could file IA.
Sir, you are not
right. IA for action is not there, but they are all.
We can't pass an order suo motu. Please file. In the case which an IA is filed, we will pass an order.
Other matter tomorrow, I'll file the IA today itself, and it will be direction will be issued. Because of the COVID situation, my lord, the students, my lord, are having some difficulty approaching and having this IA filed. Therefore, my lord, as a matter of one petitioner, my lord, I asked it to come. The parents also were down with COVID. The one petitioner, the other students who might take what act, not they.
9858/2020, heard on IA 1 of 20. 1 of what? 21? 22. 1 of 20. 22.
Latest is IA 1 of 22.
Heard on IA 1 of 22. An application seeking direction to respondent number 5 University to permit the petitioners to appear for the MBBS third professional part 2 examination, which is scheduled to commence from 22nd February 2022. Current counsel for the petitioner submitted that an excess amount of submitted that the petitioner took admission into MBBS course in academic session 2017-18. Mr. Ramesh, 2017-18. It is further submitted that the respondent number, what college? At Raj Rajeshwari Medical College, namely respondent number 6, has been recovering an excess fee of rupees 1,48,000 per student. 1,48,000 from private student every year, whereas the excess fee of rupees 48,400 has been recovered from the students who have been, from the petitioners who have been admitted against the government seat. It is also submitted 48,800. It is submitted that the admission overseeing committee, in exercise of powers under section 5 within bracket 8 of the Karnataka Education Institutions within bracket regulation of admission and determination of fee bracket close Act 2006, has directed the so and so institution or hereinafter referred to as the institution to refund the fees, and has further directed the state government to university to take appropriate action against the college to ensure under the provisions of Karnataka Education within bracket regulation of admission and determination of fee Act 2006. Full stop. Learned counsel for the petitioner submits petitioners paragraph. Learned counsel for the petitioner submits that that they have paid that each of the petitioner has paid the remainder of the fee. Submitted that the respondent number 6 college be directed to adjust the amount of excess fee recovered from the petitioners and be directed to adjust the same. It is also adjust the same towards the fee payable by the petitioner. It is further submitted that balance amount of fee has already been paid by the petitioners. Just a minute, his submission. Learned counsel for respondent on the other end, learned counsel for respondent number 6 has just a minute has disputed the aforesaid submission. Full stop. Paragraph. Learned then say balance amount of fee has been paid, and the learned counsel for the petitioner has invited the attention of this court to a chart which is annexed at page 47 of the IA. Paragraph. We have considered the submissions made on both sides and have perused the record. Full stop. It is pertinent to mention here that in the instant petition there are 10 students, 10 petitioners. However, the chart contains the names of as many as 29 students. 29 students. Full stop. From perusal of the chart, it is also evident that the petitioners have not disclosed the date of payment of the balance fee for the academic session 2020. Full stop. Full stop. The aforesaid finding, the finding on the aforesaid issue is a finding of fact. Full stop. Therefore, in the fact situation of the case and in the absence of any particulars furnished by the petitioners, it has become imperative for this court to direct the university to furnish a chart showing the amount of excess fee recovered from each of the petitioner and the remainder of along with details of remainder fee paid by them. Full stop. The chart shall clearly indicate the amount payable to excess amount payable to each of the petitioner as well as the assertion as well as a statement with regard to the fact whether or not the assertion of the petitioners that an excess amount of fee has been recovered from them. The chart shall also state whether after adjustment of the excess fee recovered from the petitioners, if any, whether the remainder amount, what is the remainder amount and whether it is payable by the petitioners. Full stop. Pending adjudication in the interest of justice, pending the aforesaid pending adjudication, of the aforesaid issue in the interest of the petitioners, taking into account the fact that they have that the interest of they are permitted to appear in the third year MBBS Part 2 examination, which is scheduled to commence from 22nd February 2022 provisionally, subject to result of the writ petition. It is made clear that the issue with regard to payment of the remainder fee, issue with regard to payment of fee by the petitioner with regard to third MBBS Part 2 course is kept open, which shall be adjudicated on the next date of hearing, which shall be adjudicated during the course of hearing of the petition. Right? Then you say this order shall be made applicable in other writ petitions as well. When do you want? Needless to you say shall prepare a chart, right? Needless to state that aforesaid exercise shall be carried out by the university after affording an opportunity of hearing to the petitioner and to respondent number 5, college 6 college. It is also directed that the petitioners as well as respondent number 5 college shall 6 college shall cooperate, institute whatever you write. It shall cooperate with the university and shall produce all the material in order to enable the university to carry out the aforesaid exercise. Based on which date tell us now? 28th February. 28th February. Right? You will be able to get it done by that time. They have to only produce the receipts and all that. You prepare the chart properly, right? It will be easy for us. We should be able to look at it and find out what the rest. Student wise, what is the amount, when it has been paid, and they are on their own adjusting the amount, we don't know. No, nothing. We have kept Mr. List along with WP number. Where is it? Which number? Which number? Is it 4288? Of course, Mr. I mean, we have not done anything. I'm only secondly, we have not collected the excess amount. These are the amount which we have collected at a different extent. So what has to go? There's no point in arguing when we have said that we have kept the issue open. We are not going to do it. We have not done anything. It would have been decided today had he assisted us effectively. What to do? Can't.
was on the 11th of February, but they will be directed to accept the payment of fees and
He means what? What fee?
university fee, university examination fee. University
All right,
examination.
what have you written? Fee, examination fee also you are not paid. And you did not owe any. Why did you not pay admission? This was not in dispute, examination fee.
Paid directly to college, I am told. But college, I mean, university is refusing to access it. But just come to the college.
When it has been paid?
To the university. Online it has been paid.
When?
It has been paid on the 10th of February. 11th was the last.
We will say that in case examination fee has been paid on 10th, you will be permitted to appear.
Yes, my lord, some students are not paid.
No, this is what that doesn't give you a license, Mr. Coming to the court and flouting everything. You did not owe anything to you. The university did not recover in excess anything from you. Why you did not pay the examination fee?
The procedure is it has to be paid to the college. College is refusing to accept. Yes,
No, you are saying you have just now made a statement. 10th of February it has been paid. That's good enough.
Students are paid on. Some of the students are paid. In case some one or two students are not.
Hey, why? I mean, see, Mr. Patil, I mean, coming to the court does not give you license to violate everything and do whatever you feel like. No, we will not tell those students. I mean, we will dismiss their petition. What is this? Why they should not pay the examination fee by last date? Because they are before the High Court, right?
College refused to accept the examination fee.
Where is the affidavit? Who has not paid? Where is that affidavit? Who has give a list of candidates who have petitioners who have paid the examination fee? So, Mr. Ramesh, best thing is create confusion to such an extent and get away with it, right? No. There's nothing to smile, Mr. Patil. We are disappointed. So what is all this? Really, no, he has argued before us cases with such a brevity. We are surprised. He's not prepared or whatever. We don't know. So nothing. What paragraph 5? List of candidates, petitioners who have paid the examination fee and those who have not. What para 5? Who has paid? Petitioners in which petitions have paid the examination fee?
Petitioners across the board. Most of them.
What is this?
Very well, you are comparing to that.
Yes.
They have not paid it there.
That's like an officer of the court.
That is
like an officer.
It's not in the interest of the students. The college says we will not accept the examination.
So we are, Mr. Some of
examination fee.
Mr. Patil, some of them have paid. We are asking you is who has paid, who has not.
It is something so easy for them.
All right. So we will say that those students who have paid the examination fee shall be permitted to appeal. Fine.
In case those who have not paid, just in case those who have not paid, permit them to pay today or tomorrow itself, and it should be how to pay.
Why? Tell us. Why they have not paid? Tell us a good ground.
Because the college, my lord, is refusing to accept.
No, how support from some of them it has accepted.
They last year, no.
That's what we are. Please understand this. The question is very simple. There are how many petitioners? 29 in this bunch, right? How many of them have paid and who are the ones who have not paid? Tell us simple.
So my instructions are, my information is not. They have contacted the
Find out.
university. On facts.
We have passed an order in your favor, Mr. Patil.
100%.
Despite that, you have grievance. What can be done?
Yes.
Yes.
And therefore, leave it at that. I have not pressed the application.
No.
I wanted to take on record this submission saying that we have approached the university on the 4th and the 8th of February. They say the procedure is. They say the procedure is university cannot access its university examination fee directly. It has to be credited to the college first. College will in turn forward the university examination fee along with all the relevant, all this I have stated in my application. The college will forward.
Congress says we will not accept your university examination fee because
I don't think, Mr. Patil, that we can be more magnanimous to you and pass an order in respect of students who have not even filed an IA.
I don't want.
No, I mean, and despite that, I mean, in one petition you have filed, you want to make it applicable without giving us details who all have paid the fee, who have not. It's a simple question.
That information I don't have. Therefore, I am satisfied with this one. Information I don't have. Because this has happened only on the 10th and 11th last week. Then 12th and 13th were holidays. This has happened. 10th, 11th was the last day.
Fine. So don't, I mean, if you want to be sure, we will list it tomorrow. There's nothing. The examination, as it is, we have passed an order. We will permit you to appear. Please tell us tomorrow. No, not this order will be passed tomorrow. But you have to give the.
I give the list of each and every student who has paid the university examination fee. The list of students who have not paid the university examination fee. If everybody has paid.
The end of this. Yes, we are only saying we can add this if you want. And those who have the university shall permit the those of the petitioners who have paid the examination fee to appear in so and so examination. Right? That's it. Paid before on or before last day. Right?
Some of them have not actually what I suggest in the hand tomorrow in case some of those who have not paid within the last day.
No, you will have to file an application in their cases saying that for this reason we could not be we were prevented.
No, the students all the restrictions, some of them, most of them have paid. It could be that one or two of them because of certain reasons. They are all from outside Karnataka. They have come recently only for this examination. There were no classes. This is all online classes being conducted. Therefore, they may have had some difficulty. That is all. I am facing the difficulty.
So tomorrow? Tomorrow.
This
tomorrow. Or is it tomorrow? For an interim order. List for orders on IA. So tomorrow.
1 of 22.
One of 22.
So party in relation to the writing.
Yes.
Respondents are served and respondents are served and under present.
So we'll have to admit it, right? Formally, notice will have to be admitted for hearing notice. Yep.
41. Government advocate.
Yes.
Column 9. The accused name has been column 10. Accused name mentioned is another one. But the petitioner is Jaina, brother's name. Jaina is not the accused name according to their. Because the land belongs to the brother of the petitioner. Land is government land. Unfortunately, both below they are not produced the document. But in the inquiry report, specifically mentioned accused name brother. In case they have filed against the not the accused.
When? What was the order passed? When was the order passed?
Same situation. He has not produced any document. No amount of evidence. Yes, you have not appeared before the special court. You have not produced paragraph 16. Then there was
in the government document itself shows that AP's name is different.
1990. There was forest offense case in 1990. You have participated in it.
Column is there, column 10, and also here put the land grant certificate in the name of the brother.
You have cross-examined the witness also. Then every opportunity is been given to you.
Anything else, Mr. Desai?
Because here 37 acres of this is the but he has to grant here. Can it be not included by producing the coding unfortunately? Last time I tried to demonstrate before this.
No. It is the document. It will matter that they have been seen. The document is producing it now. There is one problem. We don't know the veracity. These are not the proof there. So veracity, genuineness of that, which have not been examined there. We produce it here for the first time. And here we have to do nothing to respect it.
Yes, we'll consider. Thank you.
Number 42, Sri Srinivas K.
Union Bank of India. I may be permitted to not to increase the Union Bank of India as the responding. Need Union Bank of India to carry out this. I mean, how much time? 1 week's time granted to amend the cost type.
43, Sri Sanjay Nayak.
Appearing on behalf of the petitioner, my lord. My lord, in this case, last time they had sought time to file objections, the government. I don't think they filed objections, my lord, till today, my lord. No, my lord.
Yes.
Can I submit on merits, my lord?
Yes. Admission, no, you have to argue on admission.
Very well. My lord, the question involved is, my lord, the petitioner has constructed apartments in Bangalore South, my lord, adjacent to a forest land, my lord, which is a reserved forest, for which, my lord, there was an encroachment. We had encroached some particular portion. My lord, under the Forest Act, because once the land is a forest land, Land Revenue Act is not applicable, my lord, as held by the Honorable Supreme Court, and covered. It's only under the Forest Act you have to proceed, and under no other act, my lord, because forest offence can be punished only under the Forest Act. So, my lord, we had encroached. Page 74, my lord, I'm sorry, it is in Kannada, my lord. The Assistant Range Forest Officer issued notice to us under section 65. I apologize, it's in Kannada, my lord. Page 74.
Yes.
He issued notice to us, my lord, under section 64A of the Forest Act, which was rightly so, my lord. Then, my lord, we filed objections and the matter was heard. He came to a conclusion, my lord, that we have encroached to the extent of 5 guntas of land. We filed an appeal, page 80, my lord. There was a joint survey conducted, my lord, at the instance of the Conservator of Forest. Page 80 is the order. The operative portion will be page 81, which is in English, my lord, last paragraph.
Yes.
Kindly permit me to read that, my lord. This is by the Conservator of Forest under the Forest Act. Subsequently, Range Forest Officer, that is Respondent 3, in report dated 13/12, has stated that appellant has shifted the compound wall.
No, you are ready to argue, you have nothing to say. He's arguing.
Yeah, because the question of jurisdiction will arise, my lord, it's covered because they can't initiate proceedings under Land Grabbing Act. When you have already initiated proceedings under the Forest Act, this court is seized of the matter, interim order of stay is also granted. So I can't be double jeopardy, my lord. Once under this act, you have to elect, my lord, and there is no jurisdiction.
So he is praying for time, government advocate. Let him find out.
Very well, I have no objection. I have no objection.
Ananta Mandi, Senior Counsel for the petitioner with so and so. Mr. Whatever. Pray for is granted a week's time to enable him to file objections. Interim order granted on earlier occasion shall continue till the date of hearing 28th February.
I will oblige.
Customer matter number 17.
Hurry, 17 has to be taken at 1:15, right? Madam is appearing, right? Huh? 1:15, right? This that appeal thing, no? 1:15 we have got. Good. Yep. Government. State government. Take it up. Yes.
Number 31. 31. The Sharvana X.
That was 150. That is 150. Both cases.
Number 90.
Objections have been filed by CPA.
Okay.
They have filed an impeding next week. They have filed their objections as if they are a party already. They have filed objections only for the impeding petition.
We don't know. Next week, yes, place for Court of Counsel for petitioner list next week. 20. Your other case is coming up next 21st. List on 21st February.
My lord, I'm appearing on behalf of the respondent, my lord. I'm appearing for the respondent counsel.
Come this side. This is for respondent. Yes.
He's present.
Yes, the other side counsel, you are not there. We made a request for next week. Akash B. Shetty, learned counsel for the absent. Counsel for respondent, praise for adjournment list next week. What happened to this decision of the tribunal in the Supreme Court? Find out. Appeal was pending, right? What happened? Otherwise, it's covered by decision of the tribunal. Tell us why we should not follow it. It has been reasons have been assigned. Yes, fine.
Finally.
A final hearing, number 45, Sri B.S. Balachandran, Sri K.V. Arvind.
It, which is 20. Mark the presence. Sri Shankar learned senior counsel with Mr. B.S. Balachandran, learned counsel for the revenue, Mr. B. Dilip Kumar, learned counsel for the assessee, learned counsel for the SLC revenue. List on 28th February 2020.
46, Sri date of birth, Sri Mustanna.
Yes, Mr. Bhatt. Yes, Mr. Mustanna. Ready? How much time will you take? How much time? 5 minutes. Whoa, good. Oh. I can see that as if we have heard it. We don't know.
This company had great facilities in the respondent bank. There is only one bank not speak agency. But 3 accounts, page 7. Returning papers, page 7, page 7. All admitted facts, having only the admitted facts. 3 accounts, 15352,
07, OCC 573, you will not get it now. Now, out of these 40 lakhs, a lot of which we put in this first item. The company has requested a lot to approve it to some other branches, to transfer this amount to some other branches, so that the company is trying to use it. Not it is a repeated fact. And those was be done only. Kindly see my lord, their own petition. Page 34, page 34. The OEM verified them before the DR. But out of the 40 lakhs, my lord, at our request, my lord, kindly see this para, O. It is respectfully submitted that out of the cash limit of rupees 40 lakhs sanctioned by the applicant, the first defendant wanted to enjoy the limit in different branches of the applicant bank in the following manner. Mangalore 17 points, so Hubli 7.5 to 4 lakhs, like that. It is my request. Actually, I am transferred because money is with them. I want to get transferred to that branches. These branches had separate. Next sentence also, there are field day. As requested by the first defendant, the applicant bank allowed the first defendant to enjoy the tax credit limit of 40 lakhs in the above branches. But this was disputed. Or there was default, not all these road transaction was not, property was mortgaged. The prime property manual after the town with the multi-story building was given at the second. But they included the notice under section 70. The first notice is the connection under next total they include a notice for 1,47,38,702. Page number 49. Page 49, page 49 annexed D. And if it is totaled up, 49 lakhs, they have given different paper. If it is totaled up, it comes to 1 lakh. 1,47,38,700. This was their notice. But immediately, as a good customer, I requested them went for negotiations. After negotiations, they agreed to sell 2.5 cents of land out of the mortgage account. I thought it will cover the entire loan, and therefore that understanding was. Immediately, 2.5 cents of land which was mortgaged to them was sold. And unfortunately, bank realized about 77 lakhs, 78,000. They realized about the lot. And that was credited to the bank. Then again they issued second notice. After appropriating this amount, again they issued a second notice, which is that yes, annexure E is the second notice. That was the second notice. Kindly turn to page number 52.
52 is the
second notice, 32 notices. Annexure E, page 30, 49 is the first notice. We sold 2.5 cents of land and some amount of and notice itself makes it clear. Para 2, in response to our notice, we have approached the pending page. Can I just read in response to our notice, we have approached us with a request to issue NOC for disposal of a portion of the mortgage property to the extent 7.5 cents, which was a part of properties mortgaged to us, and against which the notice was issued.
Accordingly, LOC was issued, the sale proceeds of the mortgage property 2.5 cents of rupees 75,71,563 was deposited with us. And we have adjusted the sale towards the involved bank guarantee 46,53,297 and towards OCC accounts. So and so. Therefore, my lord, they realized by selling this property 75,71,563. That is the admitted fact. And still they said, my lord, you still was 77,78,134. They have given us the breakup figures. My lord, their demand is not including all the apportioned amount and all that. Only this would be OCC accounts. Then if you get our branch, other branches, you will be. Then immediately, my lord, again, my lord, I offered for settlement. Again, I offered for settlement. And my offer pendency annexed next week. But there was protracted negotiations, and afterwards, my lord, we said clearly, our trust include on those. Yes. We make one-time payment to rupees 45 lakhs to settle our OCC account numbers 5207, 5734 and 5778. All the three accounts you have made it very clear. Then next condition was releasing us immediately from full and complete liability to you in OCC account, all the three, and hand over the Balmata side documents pledged with you. This is required for finance. We are ready to make this payment to you. You will give us a confirmatory letter to us, confirming this arrangement, so as to produce the same with our finances as per our commitment. Then, my lord, next page also, 2 sentences. On receiving your approval letter confirming the acceptance of the approval, we shall make arrangements for immediate payment as mentioned herein, and you shall relieve us from the liability and dues to you in OCC account 5207, 5734 and 5778 and hand over the documents pledged with you, as that is required for the finance arrangement. You kindly making satisfaction of Balmata rate reduced to your charges and complete satisfaction of charge in OCC account at the registrar of company. Therefore, we said we share entire liability for all the three accounts. You should permit us except 45 lakhs. Clear cut off. We made also clear because property we intend to sell it to some private source to be borrowed it and paid it, got this released and sold up. But they accepted it. Can you see our next page? They accepted it. Page 56. Your proposal for one-time settlement, reference top, subject UCC account with us, then reference. Your proposal for one-time settlement of dues to 2nd May 2005. Then the title come to first clause. We are pleased to inform you that the competent authority have accepted, considered your proposal favorably, and the following has submitted to accept rupees 45 lakhs in full and final settlement of the OCC account. But I am after discussion I am reading in full and final settlement of the OCC account with us, that is Ampakrata branch. The compromise amount is payable within 7 days from the date of the settlement. The title deed for the property market will be released on receipt of 45 lakhs. For purpose of your generating fund. So then immediately we paid it. 45 lakhs is already in one installment we pay to the bank. And in accordance with this agreement, fortunately, bank released also the market property. The entire property was released. They gave us the title document. But we sold it also. But strangely, my lord, thereafter, as per election year, suppressing all this. My lord, you are winding up notice was issued. I didn't see another election year. They wonder. Winding up notice, there is absolutely nothing, my lord. They refer to these three. What is the account? There are 4 days. You had last away from my client. Page, my lord, page 58. Next page. You had everything from my client back to the facility as well. Both in the all the three OCC accounts are managed. Then when I issue the detailed reply, they clearly admit that also I am making it clear. Clear only we joined one sentence. 72. Para 3. The record of the bank and that will company to bear will 72. Para 3. Record of the bank and that of the company will bear to that of the transaction of your company was with my client's bank at Hampankata, go to market. For operational convenience at your request, the same facility of your portion of the sanction limit was permitted to be carried on the stated 5 branches of my client's bank. That is, out of the total limit of rupees 45 lakhs, 40 lakhs, rupees 22.5 lakh was apportioned and permitted to operate in 5 branches. But it is part of one pool.
Right. So the issue is whether it was a one-time settlement of all dues or only in respect of Hampankata branch. That's the thing.
If there is any liability to the other branches, they should be issued. That is not my submission is that no part of this OCC account is spent. If there is any other, there are 3 OCC accounts. We are offered security for that. Wherever money is once it is sanctioned, we get it transferred. That is how we understood. But subsequently, this totally, when we give the reply, they themselves say that is part of the OCC account. So the claim is clear by only by Hampankata Bank. No other bank. But we pointed out and when we replied, they filed an OA before the DR. DR insisted very right. I will be the R of the DR. And I said, yes.
First time. You said first time DRT.
First time. I was about to say the same thing. Yeah, para 110. Clear that here banks have only this genuine player. That is how they need. Page 110. Second, as per exhibit D10, the defendant number 1 made rupees 45 lakhs payment and part for release of the document and release the document. Further, exhibit D11 discloses that the Canara Bank branch manager from senior manager issued the certificate stating that the monthly branch bank at Rosie at account OD number required to disclose the nil balance as on 31/3/2006. Further, D12 discloses that the account number 105 defendant number 1 company was nil in the traffic island branch at Rosie. As per exhibit D13, the account number OD so and so at Kalsipalayam branch Bangalore was nil as on 16/3/2006, which was issued on 11/7/2006. Again, as per exhibit C, implies that one-time settlement proposal of rupees 45 lakhs payment by defendant number 1 was clearly disclosed that the said payment was made for settlement of 3 accounts maintained at Hampankata branch. As per the applicant bank states that the defendant number 1 agreed to clear the notes which were paid by his according to Hampankata branch were not paid as per the settlement, and the settlement was withdrawn, which gave rise for filing of the certificate. If that is the position, what made the other branches showing nil balance as per exhibit D11, it clearly implies that the state settlement of these 3 accounts was maintained in Hampankata branch. Bangalore includes the payment available by the defendants at other branches as maintained by the applicant bank. So, as and now the Hampankata branch has tried to be way before the DR, and it was dismissed by the DR. Then they went to before DR meeting. But unfortunately, our council was absent, none of the man was heard before DR. But the DR meeting allowed it. And then I filed an application that has also been used. Coming to our going company and all honestly, we make the payment of 1, 4 and half totally zero free. The multi-story problem. And they themselves admit that it is part of one pool amount, your account and all that. Normal things we have been paying. But they gone and us. Last time you already make right remember what I had directed them to produce certain documents which they have produced along with them. It also clearly helps my case only. We have produced some. We have told that property of immediate. Immediately we have told because we had no other source. As a good company, as a good customer, we have been such a long standing customer. But exception of the bank. Banks. Multi-story complex in Kata. But we do Kata. But at least their own document they have produced around here. It was like he had finally gone. I'm 13 years. Yes. There, secretary, class number 9, you got people. This is what it is. Function from the main branch. 8.1 function from the main branch. There, next page, function of the main review of the sanctions to be done by the RO, CEO of the main branch. So it is only concerned with the main branch. Then next page. These are all the functions of the main branch. Related outstanding liability under apportioned limits at various branches should be invariably furnished. Besides, overdue reasonable details in all credit proposals submitted to the sanctioning authority by the main branch. Then here also then next function for the apportioned branch. That is also very clear. Here, number 2. When they find any irregularity, they should report to the main branch with a copy of those CO concern of the main branch. Then we are class 5. Operation of the account and movement of stocks to be monitored. Then 8. Liability at the apportioned branches should be furnished to the main branch as on the last Friday of every month. Then next one, any irregularities, overdues, deficiencies in the conduct of the account, such as check, return, etc., are to be reported to the main branch and advised to other apportioned branches and the CEO of the main branch. Then resume of account under the apportioned limit is to be sent directly to the main branch. Therefore, we have borrowed from the main branch. We have given security to the main branch. We have settled with the main branch. And we have clearly we have said that 3 OCC account used to so that I have also produced the account maintained by the other branches and selected OP2 before this. They show nil return, nil due. And all I have all the 4 maintained I have. Therefore, fine. That's it. That's all. Anything else? Nothing else. Can you just author it, You could have passed it on. I have. I have. Oh, yes, listen. Three parts. Another 3 parts are not. 8. 56. the purpose would be automatically can withdraw if you make payment as it is within the time subject to your clearance with liability about after with appropriate interest with the 30 days. That's including the legal action to recover the goods with contractual interest, giving interest as available if therefore regulatory above that. Therefore, my act of settlement is only for payment. That you ask me kindly my application statement and not very clear.
What about that nil thing? Nil, your other branch is showing nil.
Once the income is nil, I think they use every last week. Then the account has to transfer to separate account and separate number has to give. And how to take it into service. Accordingly, all these cases, my statement mentioned and also produce statement account. New account number has to give. After giving the new account number, these principal have an application to branch to give the statement of the whole number. So all six cases and this particular of my lot, you go to verify the bank. So they mentioned there are all last week
what? Okay.
800.
800. Yes.
You know that good everything.
800, yes.
So that's the new number. This entire new number. But we are statement of old number. Old number
Oh, where is new number? No. You are referring to page 100, right? Where is new?
2047.
No, 2047.
Annexure R9.
Page 100. Account number is OTC 2007. Not 2047, it's 2007.
New number, old number. Last thing had the number 4, which is a great name, old number. New number is 596. That is all the cases and old number.
Where are you reading? Page number 5, para 4. Yeah.
He submitted.
Interest was not paid to loan account. Application is after procedure. The respondent bank certificate to the unemployed accrued interest from the prisoner. The prisoner are due to bank some of the secured interest from as interest to the respondent bank. Both traffic agent, old number was 289, new number was 289, this is some other number. So all statements are recognized by the DRC. It is that all statements are running account, but it is a different number. That is that principle is also right because you are not actually airport. But when fully valid, he applied for the airport ticket and the new number, old number. That is not the airport ticket actually new. Another thing that you like to make out here is apportionment. Apportionment cannot be produced. Yes, man, it's clear and saying that the main branch only has to file in the all its branches. Not that they have done. That is my lord. I am the
Oh, yes. Huh? 20. Hmm. 1612, right? Working capital finance. Ah, 620. One small 12. Ah. Thirteen, 12.
Second letter. Understand? This is the letter into the bank. You understand? That's to you document on it to you and who is settled by payment of 5 lakhs. You now one day it's not matter that it will be as I
All right. Yes. All. Very well. Undertaking to clear the liability in respect of remaining grant. All right. All. Yes.
Page 52.
What?
Their notice or annexure E issued under section 13(2). Was in respect of totally 77 lakhs, which included the claims by all the branches. Kindly see, page 52. But this is set. At our branch, now we are not getting page 52. At our branch, OTC account number 3, my lord, they mentioned 55 lakhs 29,000 so and so. Then, my lord, other branches, Hubballi, Kalasipalam, Bangalore, Madikeri, Karnataka. Total, my lord, there 22 lakhs 48,409. Lord, you get final grand total is 77 lakhs 78,144.83. This we offer, my lord, 45 lakhs in one installment. And this is they accepted. And this is in response to this period issue our annexation next week. Therefore, that is very clear there. There is absolutely no room for any.
Further,
number 44, N.K. Siddheshwara, CH Shantibhushan, Government Advocate, Sri H.K. Venkat Reddy, Marina K.
we have heard it for 2 days. We know that. We have heard it for 2 days. We have heard it for 2 hours. So, Mr. We will tell you in brief what is your case. We had the benefit of this weekend. So that's why, I mean, like you are reading, so we will tell you what is your case. Right? You say that this presidential order of 2013 is in contravention of the law laid down by Supreme Court in 2006. 2000 volume 6 715, because the executive cannot override a judicial order. Number one. Then you say section 17 of the Mysore High Court Act contains an enabling provision for establishment of circuit benches. There and Mysore High Court rules were also framed. Therefore, power under 51(2) and 51(3) of State Reorganization Act cannot be invoked as under section 69 of the States Reorganization Act provides that the powers would be invoked only in the absence of any provision of law. Right? Report submitted by Justice Jaswant Singh Committee constituted to ascertain the feasibility for constitution of any bench had recommended that there is no necessity. This report was brushed aside. Same opinion was given by Justice Ashok Bhan Committee, and the report of
I said, we are not expressing any opinion.
We are not expressing any opinion. It had not recommended, right?
So they have not, they said they will not express any opinion.
Not recommended.
Elections to elections.
Justice Ashok Bhan Committee said that no necessary. This report was upheld by the Supreme Court. Right? So then, just a minute. I mean, please, you should be sure that we have understood. That's why to cut short, because you have already argued for 2 hours. You said you will argue 1.5 hours, and still we are not at the end of it. So that's why. Okay, just a minute. So therefore, High Court ought to have reviewed the performance of the benches regarding functionality, viability, and financial sustainability by conducting performance audit. Right? Then relevant factors which are set out in Justice Jaswant Singh's Committee's reports and ought to have formed the substantive material for consultation between the stakeholders. Then guidelines mentioned in Supreme Court decision have not been taken into account. Alternative submission is that the provisions contained in 51(2) and 51(3) have been rendered unreasonable by lapse of time, and in any case, exercise of power after such a long lapse of time is unreasonable. It is not in public interest to establish benches. Then you have said section 64 of States Reorganization Act read with 49(2) and Karnataka High Court rules read with Karnataka Mysore High Court Act, and we said only one seat of justice, that is principal seat, and no other benches. Then circuit bench couldn't be set up by the High Court but could be established by the state government.
The state government has to do section 70.
That's what we are saying. Could not be set up by the High Court, but only by the state government with approval of the governor as contemplated under section 14 of Karnataka High Court Act 1961 read with section 17 of Mysore High Court Act. Then statistics show that the cases are on decline. No need for benches. Benches are not viable institution in terms of sustenance as well as statistics. Right? Power under 51(3) of States Reorganization could be assumed by Chief Justice, as he is not authorized to exercise power under 51(3) of the States Reorganization Act. There is no specific provision to establish either circuit or permanent benches. Only enabling provision is under section 17 of Mysore High Court Act. So power has to be exercised by the state government and not by Chief Justice. And presidential order does not disclose source of power under which it is issued. What else? Well,
What my grounds are.
So,
we have received as 51(2), they would have time not press. 51(2), they have mentioned it in the order. 51(2).
Yes. Does not disclose.
That ground will be right.
Now, yes. So now you can have a fair idea that we have understood broadly your case. You can develop.
This is only pertaining that to enter of the Article 23 of the Constitution. That is giving power to the Parliament to legislate, and it is part of the constitutional power to establish a new state. And if I one mentioned in Article 2, the document can see which has been also referred to in delivering the state. If I those if that is made, then you don't that this is before Article 246. You don't have to fall back on 246 to find out whether the source of power is derived from Article 246, 1 to 3 and 37. Because in many of the judgments which have been cited on my side as well as on the side, what we find is that they are referring to Article 1 and 2, and then
So what is
78?
If you want to advance any further proposition, please formulate it first and then elaborate. Because we don't understand like this. What is your submission?
My submission is that once it has been made under 2 and 3 method,
Article 2 and 3, 51 2 and Article 2. Yes. What has been made under Article 2 and 3?
It's not act has come under Article 2 and 3. And therefore, there is no necessity for finding out the source of power which is available under Article 246. With this 7.
Therefore,
is 1 and 2. Many of the judgments, the reference has been made to NP 78 and also NP 3, etc. Because now, if I am of the and Article 1 include the establishment of benches, either permanent or not. This would be one of the arguments I am proposing on the premise that 78 articles, the 78 is not required to be considered. Because it doesn't come with the establishment of the benches, either benches 51-2 or 51-3 circuit benches that arise in the newspaper. I am submitting this in view of Article 216, you want to try and see Article 216. Chapter 5 of the Court in the case. High Court for states, they tell me a High Court for each state, 215 is the High Court record and 216. Constitution of High Court. Every High Court shall consist of the chief justice and such other judges as representative made from time to time in justice proper. This is how the constitution of the High Court is. Now, because 7.
It is judgment itself, so you can't. Are you arguing that there can't be any benches of the High Court?
That can be done only in the provisions of administration of justice. That comes under 83.
The Supreme Court decision itself says that Chief Justice is the best person to decide. So please tell us, we have not still understood what is your submission. So 214, 16, all right, it provides so what?
Yes, my submission, we have referred to in that judgment.
No, please, that's what we are requesting you, Mr. Please formulate your submissions first, then elaborate. Please elaborate. What is formulate? What is the submission?
Yes, my first submission is that you also rightly said that the judgment of the Honorable Supreme Court is not overridden by.
That's fine. Apart from that, we have reproduced for your satisfaction only that we have understood what you have argued.
The second one is that if you have considered part 5 of the State Reorganization Act, then it deals with high courts. In that, it empowers the Chief Justice of the High Court in consultation with the Governor under 51(3) and in consultation with the President and the Governor under 51(2) to establish permanent benches and consultation. So these are the permanent benches. Now, this particular power is controlled by Section 69, which says that
in the absence of any provision.
Subject.
Remaining cases, Mr. will be tomorrow. Mr. Senior Counsel, tomorrow. Remaining, if you are waiting for some case.
No, I am waiting for serial number 48. 48.
So tomorrow.
Tomorrow, my lord.
Case will continue.
Right.
Remaining cases tomorrow. Yes.
Oblige.
My lord, serial number 49 may be taken up on Friday, my lord.
Okay.
Serial number 49 may be taken up on 49, my lord.
What?
May be taken up on Friday, my lord.
49:50 Friday. List on Friday. Fine. Remaining cases tomorrow. Yes, please.
My lord, serial number 52, my lord. I pray 2 weeks time, my lord.
Hey, don't make it an opportunity to get adjournment like that. The senior counsel is waiting so late. It will come tomorrow. There is no urgency in seeking an adjournment, right? We have said it will come up tomorrow. Make a mention tomorrow. What 2 weeks? Prepare it instead of seeking adjournment. You have got 24 hours. Prepare the case. Yes. 69. State reorganization.
Yes, ma'am.
Subject to any provision that may be made or after appointed date with respect to the High Court by any legislature or other authority having power to make such provision. This provision, once the High Court Act comes into effect, that is 1961 Act, it goes far beyond application.
You of what is section
69
of Mysore High Court Act.
The Act, it says,
What does not apply?
The part 5 of the SR Act says, part 5 starts from section.
Why it does not apply part 5?
Because it says, after the subject to any provision that may be made on or after appointed date.
So same, right? Mysore High Court Act, there is a provision, that is why it will not apply, right?
No, but it says.
Why you?
Because it says subject to provision that will be made on or after appointed date with respect to the High Court by any legislature. Now, after the legislature was constituted under the SR Act, there is a new act, new state came into effect in 1956, 1/11/1956. The legislature has made this new act, and in that new act it says that only by repealing the provisions of Mysore Act, certain provisions are repealed and certain provisions have been made applicable. In that section 17 has been made.
Not very clear. You see, saving clause says nothing in this part shall affect the application to the High Court for a new state of any provisions of Constitution.
Yes, sir. Then,
so this will not affect.
And this part shall have effect. So this part, if you have invoked, 51(2), 51(3), shall have effect, subject to any provision that may be made or after appointed date with respect to that High Court by any legislature. Therefore, in any legislature could either be parliament or the state legislature. So the state legislature has made a provision to make it applicable. That first thing they did not say that once the High Court is established at Bangalore.
Which state legislature are you referring to?
They are referring to the state of Karnataka.
No, which legislature, particularly which statute are you referring to?
Legislation means because it has enacted the law. State legislature has enacted the Karnataka High Court's Act. So Karnataka High Court Act, once it comes into effect, part 5 shall not have any.
That's what we told you, Mr. In the beginning, we read it out.
Yes.
And you are laboring on that. I mean, we read it out. We thought what we are thinking is that you are trying to make out some new point. So that's why we read it out to you, Mr. What else can we do? And without you taking the trouble, we did it all. We went through, we pointed out what. We told you that because of section 40, this act will not apply. Section this. Therefore, 51, 2 and 3 can't be invoked. This is the submission. It's there already. We thought that in addition to what?
Correct. No. Now that the High Court Act takes place, that holds the field.
You are not referring to that. That's it. No.
I said section
14.
Yes.
So therefore, once the High Court, the state legislature, which is the organ created under the new state, which has come into existence and has enacted, there is no necessity or need to apply part 5. So therefore, my submission to the law is that the notification which was issued or the act itself is not is void or is not.
Yes. No, it's not that difficult. We thought that you know it. We have read it out to you, right? Submissions. Again, you want us to read. I'll ask the court officer to read again. So, we have told you I'm good. Yes, what else?
And then there is another in the event of the opinion that no, High Court Act doesn't apply, and it's in 2 or 3 low. Then the act as the law said, you want to find that it cannot be referred to the act has become obsolete because it is unenforceable.
No, we have not made a point. You have made a point. Yes.
And therefore, lastly, whether the consultation, even assuming that it doesn't apply, then whether the consultation is in the form way which is done in this form.
Yes.
And the viability in view of even assuming that whether it is viable or not, there is that whether it can be done or not. Is whether it can be successful.
All right.
May I refer to? I would like to elaborate.
Yes.
State reorganization.
Yep.
State reorganization.
You are ready. Yes. Yes. Yes.
It is now very effective, like decisions of this court, binding decisions belonging to it is a decision cannot be made ineffective in the aid of any legislative power by enacting provision which is inconsistent over the judgment and is not the realm of legislative action. It replaces the basis of foundation of judgment and uniformly applies to a person. Concern with the entire subject not to be covered by such enactments and retrospectively. We may only refer to two of these judgments. A constitution based on this score in case of covering of the pattern to pronounce on the validity of the only basis litigation protection ordinance 1991 by
To write the principle of law is that statutory provision cannot be set at naught by the legislature unless the basis of that is removed. Right? Yes.
Coming to
Yes.
The section 61 is directly the rule of law. The legislature may, in certain cases, overrule or nullify a judicial or executive decision by enacting an appropriate legislation. However, without enacting an appropriate legislation, the executive or legislature cannot set a non executive or executive or legislature. Therefore, this judgment federation could not have been set at non by the Honorable High Court. The second report. Then, in this context, I have also referred to the report of the Law Council of India. The reorganization of states is given, and there is also a constitution that is given effect to in the very near future. Your thought is our duty to take this report in order to apply the government of India in time of previous years. The efficiency of the administration of the system, in our view, is the paramount consideration over this matter. The structure and constitution of the court should not be permitted to influence the political consideration. That this has happened in the past in certain cases and no valid ground for the extension of that policy. 14th document. Point 92. And that this consideration paid overwhelmingly against the illusion of the structure and composition of the board that this has happened in the past in certain cases can be no valid ground for the extension of the policy because we have only set our case against the constitution. Such a court would lead to an impairment of the efficiency of the court, the intellectual consequence of the local standards of justice. The decision of institutions of the court sit and the evidence given to us has confirmed us in the view taken by us in that report. We and 96.55. Last
56 point.
14.96 is the
55.
Since the two reports refer to your it says subject to the meaning of subject to here and 1964 how can take a population effective code of para 15, 19,
Para
para 13, 15, 18, and 19. Then we come to stage 2 and 4. The article will become ineffective and purpose. There is a particular article is to maintain after the constitution came into force, they were repealed or amended by competent authority because the aid of such article therefore would be under confusion in the field of law. The assumption underlying the article is that state law may or may not be within the state legislative competence of the appropriate authority. The article will become ineffective and purposeless if it was held that three constitutional laws to be such and to be made by appropriate authority of the constitution. The word subject to other provisions of the constitution would therefore be given reasonable and instead of subject which would carry out the intention of the maker of the constitution. It is in accord with the constitutional practice. The article prohibits the continuation of the law made by our competent authority now only the repealing of article 395 and the expression other in subject to so this further it is stated in paragraph 15 subject to other than those leading the legislative competence. word subject to other provisions of the Constitution. That is, there is an inconsistency of the conflict between the existing law and the provision of provisions. They said that inconsistency, an article of the Constitution might may come into conflict with the three constitutions. What in part? This said article or articles may also, by necessary implication, come into direct conflict with the pre-existing law. It may also be that the combined operation of the series of articles may bring about a situation which is the existence of the pre-existing law in commerce in that situation. Whatever it may be, the inconsistency must be spelled out among the other provisions of the Constitution and cannot be developed on subject versus subject to Article 277, we have already read that an agreement can be entered in the agreement with the state in terms of 30 advocating or arguing the proposal to state agreements. That part, given Article 272 continue with the constitutional laws that provision is existing, yet subject to other provisions of the Constitution. The expression subject to convey the idea of a provision leading to another provision or other provision to which it is made subject. Now, can be subject to the moment you have are high, is not high.
We continue, Mr. Bhatta. Tomorrow, we have two other motions. This for further hearing tomorrow. No, to cut short the time. We had the benefit of the weekend, that's why we told you. Otherwise, yes.
No, the annexures to Justice Ashok Bhan report, which my learned friend wanted, they are available not in the court. If the learned counsel wants to inspect them, he may do so and we'll place it.
Annexures to Justice Bhan's report are available. That's what Mr. Nagana points out. You can go through it. Record. Annexure. You can go through it. Yes. To keep it there. Yes, madam. We don't know. We don't know. Where were you, AP? Where were you when the case was called? You appeared, right? Nothing held up. There's so many lawyers who are present in their presence. We don't, madam, don't. Supposing if we grant you stay and later on Mr. Datar makes a submission behind your back and we recall the order, what will happen to you? We pass the order in presence of so many counsels. We don't encourage this practice. If you want to file an application for whatever reason, do it. prepone, whatever, recall, whatever. No. The orders were passed in presence of the council. We remember that 80, no? They are not here, madam. How can we take your statement to be correct?
Your Lordship, I am for the petition in the matter.
Yes, no. Supposing what will happen? Supposing if in one case, forget about this case. In one case, we grant you stay, right? And Mr. Ravi Shankar comes behind your back and says that it should be modified like this. You inform your client, and when you get the copy, you find that the order has been modified. What it would be? This so many councils appear. We have given a date. We don't know. You can ask for preponement of hearing, do whatever. It's a public interest litigation, madam. There can't be anything urgent in a PIL. No, that shows that had it been important or urgent, you would have remained present. That means other cases were of more.
Your Lordship, I appear for the petitioner in this matter.
You can't change the date, madam. Please file an application for preponement of hearing. Let it be listed, then we will consider. We can't do it like this. Behind the back of everybody, we can't be party to this your oral submission. Sorry, get all the counsels here who had appeared in the first round. All them.
Your Lordship,
come, we will change. Otherwise, we won't. Yes, next.
Last one matter. Number 70, CH Saravana. Government advocate.
Yes. Please cover. Given. Yes. So we can take it up, Mr. Ravi Shankar, tomorrow. Oh, tomorrow. What? Okay. In compliance of the order dated whatever, in compliance of the order dated 9/2/2022, Mr. Additional Government Advocate Titus Dev has filed the report in a sealed cover list tomorrow. Yes, Mr. Water. Yes, madam. What happened? You are able to seek instructions. What happened? No, it's all right. But what happens, supposing if eventually they succeed before you? Supposing if the appeal is allowed, what relief? All right. So, what happens if they succeed? I mean, please tell us. First, you tell us what happens if they succeed, and what happens if they fail. Either we have to consider. So, what happens? Like you are justified. Just a minute, please listen. You are perfectly justified in asking for time. We grant you time. Now, the moment we grant you time to decide the appeal, or say 2 weeks, we will say what happens to the counseling tomorrow. Now, supposing if eventually the appeal is allowed, that is the first scenario. Second is if it is rejected. Please tell us. First scenario, what happens if it is allowed? So, all right. So, can we say that 50 seats shall be filled up in mop-up round? Of course, we will immediately give a date after 5 days. Whenever you say that we will be able to pass an order, immediately the next day we will fix the date. This interim arrangement, we will say that 50 seats will not be filled up, will be filled up only, will be kept vacant, right? No, but till then, supposing. Yes. No, but what? Yes, of course. That is. That's why we will say that 66 in which MBBS course. That's the problem, madam. Supposing that's why we are talking of number. Supposing you are the whole thing has cropped up because of inaction on the part of MCI. The statute itself, they had filed the appeal well within time. By virtue, the 45 period, the period of 45 days prescribed under the Act expired. So that's why they got a right to file an appeal. In first round, just all right. You are justified in saying that you statutorily you are entitled to 45 days, but because of this 30 days. All right. Because of this mop-up round, we said within 1 week, we didn't intervene in the first round of. Now the question is how to protect their interest. Supposing if on Friday their appeal is allowed by you, we don't know what will you do with their appeal, and there are 50 seats are not left in the MBBS course. What happens? All right, you are concerned with the grant of time, right, madam? All right. So how much time tell us now? 18. By that time you will pass an order? Okay. Mr. Ravi. No, we are not permitting. We are not granting that prayer. He has understood things. I thought we thought that you have also understood what interim order. We are not permitting them to admit students. We are only saying 50 seats of this MBBS course will be kept vacant and shall be filled up in mock-up round. That's all. Yeah. That's why the other side is not there. That's why we said. They alone go. Where is Mr. KP then? Not there. That's what we are saying. Yes. Of course. No, they are not. Yes, Mr. D.R. Ravi Shankar, Learned Senior Counsel with Mr. So and so for the Mr. Sarvana S. Learned Counsel for the petitioner. Ms. Nayantara Viji Lalit, counsel for respondent number 1, right, madam? And yes, you are appearing for 2. Additional government advocate for respondent number 2. Lalit, counsel for respondent number 2, respondent number 1. On instructions, submit that the appeal, that the arguments in the appeal filed by the petitioner have been heard 11th of February 2022, and the respondent number 1 shall pass an order order in the appeal preferred by petitioner on or before 18 February, full stop. In the full stop. After hearing learned counsel for the parties, it is directed that the 50 seats of MBBS course be permitted to be filled up in mop-up round, which is scheduled to be commenced from 2nd of March 2022, subject to outcome of the appeal which has been filed before the petitioner. Needless to state that this arrangement shall continue only till 18th of February 2020. Right? List on 18th February 2020. Who is not there? Acha, Mr. Ramesh, he was there, right? R3 and R2. He was there. Mr. Ramesh. Write the name of Mr. N.K. Ramesh. That's what he said. He's not here right now. That's what he told us, that it's available in the court. You can examine the record. That's what he said.
Court master sir, item number 34 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? Court master sir, item number 34. Court master sir,
next week ಅಜ್ಜನ್ ಆಗಿದೆ.
ಹೌದಾ? Okay sir, thank you.
Court officer, serial number 51. 51 ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರ್. ಯಾವತ್ತಿಗೆ ಸರ್? ನಾಳೆಗೆ ಸರ್. ರಿಪೀಟ್ ಅಂದ್ರೆ ನಾಳೆನೆ. ಎಸ್ ಸರ್. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 22 ಕರೆದಿದ್ದೀರಾ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲ ಸರ್.
Court master sir, serial number 50.